Good morning. Mr. Val, you owe your opponent here a thank you.
Good morning and thank you. I'm so sorry. I somehow didn't realize when you said this morning that I greatly appreciate the call from staff and the opportunity to get.
Yes. We'll hear from the call the case, please.
N. Ray Lyric N.
We'll hear from the appellant. You still don't have your footstool, though.
I'm sorry. If it pleases the court, I'm Betsy Stibler from the Hamlin County Bar. It's nice to be back in person with this court this morning. I would like to reserve 5 minutes for rebuttal.
That'll be fine.
Your Honors, I would like to start today by just briefly introducing what I am certain you have read in the briefs, and that is that my client is the maternal grandmother of the child at issue in this case. The maternal grandmother's daughter passed away. Before she passed away, the child was spending time living in the maternal grandmother's home. When she passed away, obviously the father became the child's custodian, and that occurred in 2016. Grandmother retained a healthy visitation with the child. She had her for all the holidays. She had her for weeks in the summer. The father allowed her to stay with the grandmother without any type of formal custody or visitation. In 2019, and I have to remember these dates because COVID kind of delayed some of these proceedings, the child's father died. Shortly before the child's father died, and unbeknownst to grandmother, the father's half-sister, Amy T., we'll call her aunt in this situation, had petitioned the juvenile court of Hamlin County for custody of the child. Grandmother was aware that the child had been left an income-producing duplex by her paternal grandfather. And so grandmother was concerned about what would happen to that property. She filed a custody and visitation after aunt refused to allow her to continue to visit with the child in the Hamlin County Juvenile Court. After mediation, entered an agreed order giving grandmother visitation with the child and enjoining the aunt, who had by this time put the child's income-producing duplex up for sale, enjoining her from selling that duplex. Shortly thereafter, grandmother discovered that the duplex was not only still for sale, but was scheduled to close with the property transferring from the child's name to another party. That's when she filed for a guardianship in the probate court over the child's person and estate, the only court that could grant that specific relief. She received that and then proceeded to take custody of the child, stop the sale of the property, and at trial it was elicited in testimony that that occurred within a day or two of the scheduled closing of that property, that it took a copy of that order granting her the guardianship to stop the sale of that property. At that point, the aunt had not instituted any proceedings in any court requesting the relief of selling the property on the child's behalf. She had not requested a guardianship over the child's estate. She had done none of those things at that point in time, except for changed the Social Security payee to herself. Grandmother then decided that she wished to adopt her grandchild after keeping her and the grandchild expressing to her that that was her desire. Grandmother filed for an adoption. All of the relevant, despite what opposing counsel and Appellee's brief states, all of that was referenced in the petition, and it was in fact presented along with the order for the guardianship to the adoption court. The adoption was granted. All the proper notices of filing of adoption were filed in both the juvenile court and the chancery court. Chancery court later entered an order stating that the filing of the adoption proceeding had stayed any further action on the guardianship, because that's the statute. Once an adoption petition is filed, all matters transfer to the adoption court. That includes anything to do with the child's property, maintenance, custody, child support, any of those issues. After receiving notice of that filing, the appellee's counsel somehow was able to ascertain from the closed adoption file the information regarding the adoption and file a motion to set aside that adoption. After not quite a month, the trial court did in fact set aside the adoption based on the assertions in that petition. What is important is that the assertions in that petition were proven at trial to be vastly overblown. From the time that the aunt had custody of the child to the grandmother's involvement in the child, we then proceeded to a contested adoption. A trial was held and a GAL was appointed. At trial, the trial court awarded adoption to the aunt, which we think is improper, because even the GAL had remarked during his closing remarks that he had concerns about the aunt's financial positions and interests, and that something should be done to protect the child's investment property.
Counsel, excuse me for
Yes.
interrupting. I have a procedural
Yes, Your Honor.
question. I believe that the amended judgment and final decree of adoption reflects that the guardian ad litem fees are reserved for a future hearing. Have those fees been addressed?
Your Honor, I addressed that with this court specifically by motion and asked this court to enter an order directing the trial court to address that issue. I believe somewhere in the file is the response to that motion that reserving of the GAL fees is not something that precludes that from being a final order. So
your client's position is that this is a final order and that this court has jurisdiction to hear this appeal, notwithstanding the fact that the fees have not been addressed and that issue has been reserved?
it was my client's position that it was not a final order, but this court entered an order stating that it was in fact a final order, because GAL fees are fees that can be addressed in the future and do not prevent the finality of the order. And I don't have the specific language of that. But I did file a motion to direct the trial court to enter a final order, as well as a motion to extend the deadline to file the appellant brief based on that specific issue. And that is what this court entered.
Thank you.
You're welcome. So during the trial, it was shown that the child's income-producing property could have produced, during the pendency of this matter, approximately $15,000 of income that would be set aside for her future use. That was not produced because the aunt had not rented out the other half of the duplex. She had a lot of reasons for doing that. Most surrounded the fact that it was a pain for her, that it was not something that she really liked to fool with. Grandmother also has argued in the brief that there was no reason to disturb the finality of that adoption. That the argument that the aunt, as a former custodian, puts to bed any question of who should have had notice, although they did receive notice, but who should have been made a party to this adoption. She took physical and legal custody of the child. She stopped the sale of the home, and she properly adopted this child. And it is our argument that that's where this case should stop. That under the finality of adoptions doctrine, that this is an attack on that is improper by someone who didn't even have standing as a party to the adoption at that time. Further, that it's not in the best interest of the child to have entered an adoption and to an aunt who was shown to not be able to manage financially without the child's income, who couldn't manage the child's income, who stated that her own daughters used the debit card that the child's Social Security money went into to do things like rent Netflix or Hulu. And so it is the grandmother's position that that is similarly improper. And while this court doesn't typically substitute judgment for custody and visitation issues, we would submit that it was never properly before the court to change grandmother's visitation. Grandparent visitation survives adoption by a relative. Aunt, by definition, is a relative, and grandmother's adoption should have survived that. There was never any relief requested that aunt put on any proof for, or anyone else did, that the visitation should be changed. It was not tried by consent. It was not raised by the pleadings. And it was, quite frankly, a blindside when we read the opinion, because at no point was that ever on the table. So we're asking this court to reverse the judgment of setting aside the adoption. In the alternative, to reinstate grandmother's previous visitation, because that was clear error on the part of the trial court. Or to find that the adoption was not in the best interest of the child, because aunt cannot properly fulfill her obligations to look after the child's welfare and her financial condition. This child has an important income producing property that needs to be protected and is not at present.
Did you find any authority that says the grandparent visitation order will continue after the last parent has deceased?
Your Honor, I did not look up that question because the grandparent visitation order was entered after the last parent was deceased. The dad was already deceased at the time that the juvenile court and the mediation occurred and granted that visitation, finding that it was in the best interest of the child. So that had already occurred post-death of father.
And the adult who had custody of the child when that order was entered was the aunt?
The aunt, that's correct.
All right, thank you.
Yes, and she had received custody about 3 weeks, give or take a few days, prior to the father deceasing.
So your position is that grandparent visitation order should not have been modified because the circumstances haven't changed and it wasn't raised as an issue in the adoption?
Yes, Your Honor.
Good, thank you.
You have your time for rebuttal. Thank you. We'll hear from the appellee.
Thank you, Your Honor. May it please the court, my name is Donald Vowell, Knox County Bar, and I would usually spend a couple of days getting ready for oral argument, but I got the call. Somehow, as I mentioned, I don't know what happened, but I did not know we were to be here today, so I did have 10 or 15 minutes. I did actually get here at more like 10. So at 10, 15, 15, so I've looked over things, so I don't claim to know every answer. But what I do know is this. I'm looking at the situation, and I'm looking at, this is page 124 of the record. This is the trial court's order, where Judge Boniface, where she set aside the previous order. And, you know, it's not pretty. Inaccurate and misleading information in the pleadings, incomplete statements of fact by the attorneys, speaking of Ms. Stibler. And I don't like standing up here and saying this, but this is what the judge said. Incomplete statements of fact by the attorney and the testimony given in chambers. And then she said, the court said, the court did not make accurate findings of fact regarding the best interest of the minor child due to the court not being told that there was a recent juvenile court order dated June 3rd that placed custody with paternal aunt who had cared for Lyric for 3 years and was an appropriate custodian. The court was not made aware. This is how this case happened. The court was not made aware that the juvenile case was still open and active. Of course, it was open and active. And I think I can turn to the the juvenile court order said that it is therefore ordered Amy Trent is awarded the care and full custody of the child. So how in the world are we going to go somewhere and file papers that say, I'm looking now at Exhibit 43, this is the petition for adoption, comes petitioner Christina Spencer, 65 years old, and she consents to the adoption because she has guardianship. I think I just read that Amy Trent had full custody. And then she says, petitioner has no information of any proceeding concerning the child pending in a court of Tennessee. My goodness, how can that be put in a petition under these circumstances, or any other state that would affect the current proceeding? Petitioner knows of no person, not a party to this proceeding, as the court, I think, realizes. They filed this petition ex parte, did not notify Amy Trent, who had the child before. Knows of no person, not a party to this proceeding, who has legal or physical custody of the child. My goodness, I am shocked. I am shocked and overwhelmed that has been said to a court right here in East Tennessee. Petitioner obtained, this is paragraph 11, obtained legal and physical custody by her appointment as temporary guardian. So what happened, I think this comes clear in the case, they made this agreed order that Ms. Spencer would get visitation. So she goes, picks up the child on the very first visitation, and I think it was a Friday, might have been a Saturday. Next Monday, and it's not clear to me where the child was when Ms. Spencer went to court. Had she dropped the child at school? I don't know. It seems to be that Monday morning, and files this paper that says she doesn't know of any other proceedings about the child, when obviously there were. So right there, I think we have the credibility demolished, and we have someone who is just not candid and forthright with the court. And to you, well, that's exactly the word that Judge Boniface said. Petitioner was not forthright in paragraph 9 of her petition, wherein she stated that she had no information of any proceeding concerning the child pending in a court in Tennessee. So that is just, it is unbelievable to me that we're here today under these circumstances. How can anyone come in and claim to be on the right side of this case after that happened? How can this possibly be? So, moving on to another topic that I think I heard addressed. Counsel says all of that was referenced in the petition. I guess, speaking of the juvenile court case, what Judge Boniface said was that due to the court not being told there was a recent juvenile court order that placed custody with the aunt. And yet counsel here today says all of that was referenced in the petition. It wasn't. It wasn't. It just said something like, I was a party to a case in juvenile court. It made it sound like the case was over. And that's what Judge Boniface absolutely...
Mr. Vowell, let me change the topic a little bit and ask whether the original order granting the adoption in favor of the grandmother had become a final judgment prior to the judge rescinding her own order.
Your Honor, no. I wish I had the dates memorized, but there was...
Well, I have an entry date of the rescinding order entered on November 8th.
I'm looking right at it.
And in that order, the court says it didn't have information before it to make a correct ruling in the best interest of the child and rescinds its October 8th order.
what happened, and I'm looking, somehow found that, that order indeed was October 8th. 2 days later, October 10th, Mr. Talley, representing Amy Trent, filed his motion to set aside the order. So if there's any, the order had, that was, the motion was filed, and so it, it did not become a final order because the motion, the motion was filed.
All right, thank you.
Yeah, that's, so.
Now, what do you say about the, as Ms. Stibler mentioned, the doctrine of the finality of adoption?
Well, that's a very good that's a very good doctrine if you have a final order. Now, if you have an order that is set aside basically due to fraud, or whatever reason it was set aside for, that doctrine simply doesn't apply in any way. Like any order is not, final until it's final. So I certainly support the principle that once you have adopted a child, it's your child, and you are, you are the parent, and nobody can step in and interfere. But that is nothing at all like what happened here in this case.
So we again come back to the finality of the judgment, and your position is it was not a final judgment, thus the doctrine does not apply.
That's correct, Your Honor.
Thank you.
And the order gets entered on November 8th, setting it aside. The court then has a full-blown hearing and listens to everything that anyone can offer. And indeed, Ms. Stibler offered testimony about visitation. She offered it. This is page, well, it's in the record at 164.
All right, and since you brought up visitation, was the issue of the grandparents' visitation before the court in the adoption proceeding?
Your Honor, I believe that it is part and parcel of any question of being a parent, custodian, guardianship. The question of visitation is naturally subsumed in that. The question before the court was who were to be the parents. Both parties vied to be named the parent, the mother, and part and parcel of that was obviously the question of does anybody want visitation? Now, if I can segue, and I'm happy to stay right there, segue to if the question is changed circumstances, and I'm not so sure that this temporary visitation order has this sweeping effect from juvenile court, always, being there, can't be, I'm not so sure it has that effect, but if it does, then, and if the question is changed circumstances, we have changed circumstances immensely. The child, by the time we get to Judge Boniface, has been living with Amy Trent for a long time, and she has tugged, figuratively speaking, tugged on the judge's bench and said, "Let me talk to you, please." And this is a girl that is wise beyond her years. She has seen a lot. She says, "Let me talk to you, please." And she's already talked to the guardian ad litem. She talked to a couple of other people that I can't remember. And she said, it's not transcribed, but as the judge explained it, she wants to live with Amy Trent. That's a changed circumstance.
Excuse me for interrupting, counsel. I do have a question with regard to the in-camera examination. It was an in-camera examination with the child, is that correct?
That is my understanding, yes.
It's also my understanding that none of the parties, none of the attorneys, and a court reporter were not present during that in-camera examination. Is that correct?
That is also my understanding.
And procedurally, when was it announced by the trial court what transpired during that in-camera examination? Were the parties and counsel notified in advance, or was that first communicated during the memorandum of opinion that was filed in this case?
Your Honor, I think it was communicated in advance. I think it was agreed upon. The way it immediately transpired was the guardian ad litem, Scott, as the little girl calls him, said, "Your Honor, I'm going to tell you one thing. The little girl wants to talk to you privately." And the judge says, "Well, I rarely do that, but we'll see." Or I can't quote what the judge said, but something like, And so I don't think anyone objected, and I don't know. I can't stand here and tell you there was a formal agreement that the judge could do that, but I don't think it was.
Did the trial court announce what transpired during the in-camera examination before the end of trial?
Your Honor, what I think happened, I don't think so. No, please, I'm not as sharp on this as I might be if I had a little more, or thought I had a little more time. But I think the judge initially said she was going to tell the parties what was said. And then she later in the order, maybe she said, I've decided to, because she didn't want to put the little girl in the hot seat. I think that's what she said.
Notwithstanding any agreement by the parties for this in-camera examination and the nature of it and the scope of it, was it error for the trial court to conduct an in-camera examination of the child without the parties, without the lawyers, without a court reporter, with no transcript, and before the end of the trial?
Your Honor, I don't think so. I think that is within the discretion of the court as to do that. And if there was somehow some procedural, if there was somehow a principle that the court couldn't do that, I think that it's incumbent upon the party who later, to object at the time, rather than wait and see what happens. And then if you don't like it, then jump, there's a problem, you shouldn't have interviewed her in camera. I think that you very much have to raise an objection if you have one timely and contemporaneously.
Thank you.
You've used your time, Mr. Bowell.
All right, thank you so much, Your Honor. I greatly appreciate the opportunity to have an oral argument today.
We'll hear from the appellant now.
To address Judge Frierson's question, the answer is no. It was not announced to the parties before the end of the trial, and the first that we heard about it was actually in the memorandum opinion. It was when the issue came up at the end of trial for the in-camera interview. The trial court stated that that would be shared prior to the judgment being entered in the case, prior to her decision. That did not happen, and there was not an opportunity to object because the memorandum opinion came while we were ostensibly still waiting for this communication. The
Counsel,
issue...
is all that in the record? Is there a transcript to that?
It is in the record, Your Honor. And the issue was you have to pay attention to the dates, because as happened when courts resumed after COVID, we wound up doing split days. And so one was before a weekend, one was after the weekend, and she specifically said that she did not want to announce to the parties what the child had said prior to a weekend. Okay? So there were a lot of things going on. As far as the argument that...
Let me back up.
Sure.
You said the first you heard of the in-camera hearing was when the opinion was released.
I'm sorry, I wasn't clear. The first that I heard what the child stated as according to the trial court. That was the first information we got about what occurred during that in-camera
But you
review.
knew ahead that the court was going to conduct an in-camera interview?
Yes, we did, Your Honor. And part of the reason why we did not object to an in-camera interview is because we were assured we would know what the child had said so that we could, act accordingly. And it was not told to us at that point or any other until after a proof was, closed that she was not going to disclose that. Now,
Counsel, if you didn't object to the in-camera hearing itself, what would your objection been to if the judge had disclosed what the child said? I mean, what kind of objection would you have raised?
well, we could have, there were several things that there was proof put on about, such as the fact that Aunt used the COVID relief money that she got on behalf of the children that live in her house, including this child, to purchase a cruise for the family and the child was aware of it, that departed shortly after this trial. And so, as the GAL stated and Mr. Val stated, this child is a people pleaser. We believe we might have had an opportunity to ascertain at that point whether or not she was essentially bribed, which is one reason why you look at a younger child's reasonable preferences, what goes into reasonability. That being, a small part of the argument as to why we're here today, but something nonetheless that we felt was error on the part of the trial court. Mr. Vowell suggested that because we mentioned the fact that grandmother maintained a relationship through court-ordered visitation, that opened it up to a change. And we know that that's not true. That's not the case of family law, custody, and visitation law. And that is because people deserve notice. They need to know what they need to put on. They need to know what is going to be alleged against them. When it comes to the finality of this order, Your Honor is right. Adoption orders are final when they are signed. That is when an adoption order is final. The proper vehicle to dislodge an adoption order is not a motion, which doesn't stay the finality of the judgment, but rather to remove parental rights from the adopting party. And that didn't occur here. And that was another part of our argument. None of those things happened. So procedurally,
so
it was proper.
there's no right of appeal from an adoption order?
There could be a right of appeal from an adoption order from parties. For example, when we do termination of parental rights and adoptions, those are typically at the adoption level.
Let's just keep it simple. Let's just
A contested adoption.
stay with an adoption. What I hear you saying is there's no right of appeal.
No, that is not what I'm saying.
That's what I heard.
Okay, well, let me clear that up. Typically, with an adoption, you've got two kinds of an adoption. A non-contested adoption, wherein someone's terminated.
Let's keep it simple. This one's a contested
A
adoption.
contested adoption. If there is a contested adoption with the proper parties before the court, there's absolutely a right of appeal.
Well, then, isn't that what we have?
We did not, because at that point, Miss Aunt was a former custodian of this child. And that goes to the next part of my argument, which
Well,
is
who else would be a proper party? Just your client?
just my client, because she had legal and physical custody as required by the adoption statutes to do that adoption. And one reason why is because quite frequently children are adopted after a termination of parental rights in juvenile court or after a custody issue. We see that all the time. There's a reason that the statute precludes notice of former custodians, and that is so you don't get a three-ring circus, which is essentially what this could have turned into, and arguably may have, in fact.
Thank you.
Thank you.
Court's thanks to both counsel. We appreciate your arguments today and your briefs on this. Please be careful of the weather outside. If it's like it was when we got here earlier, watch what you're doing. Recess court till this afternoon, please.
All rise. This court is now in recess until 1:30 this afternoon.
Thank you.